except a few in LPM and LWD, which we'll cover in tomorrow and the next week. So in terms of probate, we have said that there are three parts you must master very well. The first part is testacy, the second part is intestacy, and the third part is grants. Now, when you talk about testacy, that is the politics of wills. You need to master that very well as well. The politics of wills. What is it about wills and all that? The next one is intestacy, the rules of intestacy, where there is no will, who then is entitled to inherit? How do they inherit? How do you prepare their schedule of distribution? Okay. The last part that you need to understand is now the grants. How then do you move the court and what is the procedure of moving the court? So you will realize that those questions are usually very, very constant. When you talk about question one, all question ones all the time will be involving testacy and some parts of intestacy or to some extent grants. So question one will sometimes cover a lot of things, but normally centered around making of wills, validity of wills, and all that. So just get the concept and then everything else will be flowing. Probate is one unit that should not give you pressure, but I understand some of you don't have the Kenyan law background. That means they did law in different jurisdictions, as well as some of you don't just like probate for whatever reason, which is fine. But please get to understand the three concepts clearly, because that is all. Another thing you need to understand in probate first also is the entitlements in terms of what is a child entitled to, what is generally section 29, who are the dependents, who are the beneficiaries, and under what circumstances can they inherit. Once you understand that, everything is good. So again, don't give yourself pressure. Johnston was approaching 100 years. I think they were supposed to write Jacktone because that is a prophecy of mine. I'm the one who will be approaching 100 years. Anyway, read that. Somebody read for us the question so that we can see.
Okay, I can read.
Mm-hmm.
Question 1. Johnston was approaching 100 years. He had 3 wives and 15 children. His estate comprised of 100 acres of prime land in Ushindi district, Tukutane Bar and Lodging in Utawala town, plot number 10 Ushindi town, which comprised of 20 bedsitters, a Land Rover vehicle, a modern townhouse built on 1 acre of land in Buxton City, which was owned jointly with his daughter Valerie as tenants in common. On his 100th birthday, he had a premonition that made him feel his days were numbered on earth. He told his wives and children that he wanted to see them all on 20th August 2014 so that he could give instructions on his wealth. On the said date of the meeting, they all attended except his first wife Angelina, as she was feeling unwell. Johnston did not take this kindly and felt he was disrespected by her. After giving a long speech, Johnston stated, "The 100 acres of land I have in Ushindi district shall be divided equally among my children. Tukutane Bar and Lodging shall be inherited by my grandchildren in equal shares, and they shall be at liberty to sell it if they are unable to run the business. Plot number 10 shall be inherited by my second and third wife, Maria and Rahab, respectively. They shall be dividing the rental proceeds equally, and if they sell, they shall divide the proceeds equally. The Land Rover shall be inherited by my son Ashton, since he has been driving me around in it and has taken good care of it. The 1 acre in Buxton City shall go to Valerie, since she helped me build the house, and in case she decides to sell it, she shall give 10% of the proceeds of sale to my dear nephew, Johnny Johnston, my sister Agatha's, my sisters Agatha's son, who is named after me. The residue of my belongings shall be inherited by all my wives. My first wife, Angelina, shall continue living in the house I built her in 1969 as the title is in her name. My dwelling house shall remain a family home for my children, grandchildren, and those that will come after them. Ashton wrote down his father's wishes on a piece of paper, and his father affixed his thumbprint. 2 months later, Johnston fell and hit his head on the floor and was admitted in hospital. The injury made him mentally unstable. His wife Rahab visited him with her cousin's son Roy, who was a lawyer, and she told Johnston that he needed to write a will. In a state of confusion, Johnston nodded and told Rahab to come with a written document for him to sign. Rahab visited the following day with a document written. Kindly scroll. Written last will. According to the document, Rahab was named executor, and all the assets of the deceased were bequeathed to Rahab and her children, except for the Land Rover, which remained with Ashton, who was the son of Maria. The will was executed by Johnston in his hospital bed and was witnessed by Roy and Rahab. Johnston died a week later. A. In light of the narrative, using case law and relevant statutory provisions, give a legal opinion on the validity of the two wills.
All right. Thank you very much. Thank you very much. So, guys, this is uh, a very simple thing. Somebody is having the microphone on. Please mute. This is well. Are you breathing or are you? Who is that? Please mute your microphone. You can hear some very funny background things. Thank you very much. All right. So normally question ones are set like this: validity of wills. All the times you'll find questions of this nature. So in this instance, we have two wills. Okay. The first will is this will that was made. Let me. This will that is made at this time, the one that you can see in that quotation. And then the second one is this one. Okay. So when this person was sick, the wife Rahab visited him with a cousin son Roy, who was a lawyer. Okay. And then they asked this Mr. Johnston to write a will. Okay. And then Mr. Johnson nodded, and then they came back the following day with a document that is written as the last will. Okay. Now, you need to, in light of this narrative, these two wills, using case law and relevant statutory provisions, give the legal opinion on the validity of the wills. So, guys, you're not going to draft a legal opinion like a letter. No, that is not what the question is looking for. The question is just asking you to discuss the validity of this, of the two wills. So, will number one, the will dated this date, and the second will dated this date. Okay, if you're not given date, of course, you're given the first answer. So the first will, is it valid and why is it valid? The second will, is it valid or is it not valid? Now, in doing so, guys, we have talked about the validity of wills. And anytime you're discussing the validity of wills, there are three things you need to consider. The first one is the question of capacity. Has it met the capacity test? Number two, you discuss the question of the formal requirements of that will. Formal requirements, things like, has it been signed? Has it been attested? Okay. And then you look at the question of vitiating factors, which is number three. So I've said that the will can meet the first test, but it fails the second, or it can meet the first and second, but it fails the third. Okay. An example is a will can be prepared by the testator who is properly capacitated. Okay, they have proper capacity. Number two, they could be that will could have been attested properly and executed properly. And then lastly, that will fails the test of vitiating factors, which is a question to do with mistake, things to do with undue influence, things to do with fraud, things to do with knowledge and approval, and all those factors. So you look at all those. You look at all those three angles, and then you address yourself and ask yourself whether that will is valid. But I've said for purposes of discussing the validity, you don't need to go and discuss the vitiating factors individually. Don't start saying is there certainty, was there mistake, was there fraud? No. When it comes to vitiating factors, you only pick it out. Okay, you only pick it out when the question gives you an instance of certainty or undue influence and all that. So those are vitiating factors that may vitiate an entire will, or it might vitiate just as a portion of the gift. Maybe within the question or the questions to come, we will see. So in this question, somebody tell me, what are we looking at? And of course, again, because of time, I've said there are two things: the formal requirements and the capacity. Now, there are obvious cases like Banks versus Goodfellow, which of course is the locus classicus case when it comes to the questions of capacity and the questions of validity of wills regarding the mental status of the deceased person or of the testator. So you have that case in mind and other cases, but also you have the requirements under section 11. So you proceed and discuss the validity of that specific will, whether you think that this will is valid or this will is invalid. Okay. Now, in addressing that question, you start with the first will and you answer the question as, is it valid or not? It is not valid. Why is it not valid? Okay, so you can say, yes, it is valid, or no, it is not valid, and then you give your reasons under that. Or you can start by defining, giving the legal premise, and then giving us the conclusion. So you can start with either. You can say it is valid for the following reasons, or it is not valid for the following reasons. Or you can just give us what the law provides, and then you give a conclusion at the end. Either way works. So quickly, let's have two people discussing with us part A, which is the validity of the two wills. Validity of the two wills. So again, at this point, guys, because some of you have read wills, you have 10 cases. So this is not your time to shine. Okay, there is that temptation. Also, when you get to a question in an exam where you don't understand other questions, but there's one question that you know very well, don't write 10 cases. Don't write 5 cases. Don't even write 3 cases. I would not even advise you write 2 cases. One is enough. Okay, one is enough because of time. Just give us the law, give us the case, and move on. If you don't have the case, move on. So don't start quoting Banks versus Goodfellow, this and this, Murthy versus Murthy, or Vijay Shah versus public trustee. Fine, you can do that, and you will get marks as you do that. But remember, you will get the same marks as the person that wrote one case because of time. And in this question, you don't want to waste time. Okay, so using case law and the relevant statutory provisions, which will is which and what is the law there under. Somebody, mikono zinafaa zikuwe juu sai so that we don't waste time. Mnaona what is happening? Nobody's having their hand up. So let's go back to the first will. Let's go back to the first will. This will here. Okay, on the 100th birthday. Okay, so this person has had a premonition that made him feel like his days on earth are numbered. You know, he has told his wives and children to see. To see him on the 20th of August 2014. Now that is a will dated 20th of August 2014. So is that will valid, and why is it valid? And so let's start with Abdisalan. So your introductory paragraph would be the validity of the will dated 20th August 2014. You underline, and then you give us your arguments and your point and your conclusion. Abdisalam, we can't hear you. You are muted.
The will is invalid. The will of 20th August is invalid in the sense that although Mr. Johnson had the capacity to make a will, the will has been attested by his son, has been witnessed by his son alone, who is also a beneficiary. It would have been signed by two other independent witnesses. So in that context, I think it was invalid.
My friend, which part of Kenya are you?
Very far.
No, not too far. I can reach you anytime, anywhere. I can send my people to come and say hi to you. What do you mean, Abdisalam? What do you mean that this will is signed by the son? Okay, what do you mean that this will is signed by the son? Guys, let me take something away from your mind. Two things that confuse people in probate. The first thing, the fact that a will has been signed by a beneficiary doesn't mean the will is invalid. The will is very, very valid. So long as a will has been signed by a human being who is above the age of 18 and is not mad or insane, that will is valid.
Yeah,
Okay?
it is valid. The will is valid, but it has not been attested to by two independent witnesses.
So it is invalid.
In that sense, it's invalid because it's not been attested to. It has been signed by the Johnson himself. Yes,
Abdisalam, don't confuse this point, please. Don't confuse the point. The point is, you, Abdisalam, you make a will today and you call your children to sign that will. That will is very valid. Whether you get other independent witnesses or not, the will is valid. Unaelewa? So long as a will has been signed by a human being who is above the age of 18, okay? When you look at section 11, it is not saying that the will should not be signed by a beneficiary. No. So long as a will has been signed, by a human being, okay, who is above the age of 18 and has their mental capacity in check, the will is valid. However, when that will is signed by a beneficiary, what is invalid is the gift given to that beneficiary, unless the will has been signed by another person, okay, who is not a beneficiary. So we are saying, if you make a will today and you give everything to your children, and your children have signed the will is valid, but their gift is not valid unless you get somebody else or they get two other people to come and sign. Now, it doesn't mean there have to be two people. So for instance, if you have your son and your daughter sign the will, then it means you have to get two more people who are independent witnesses come and sign the will after them. But if you get your son and a friend of yours sign the will, then you don't need to get two. You just get one more. Why? Because only one beneficiary is signed. So the number of extra witnesses you need to get depends on the number of beneficiaries who have signed the will. Tutaelewana?
Okay. Nimefahamu sasa.
So that means that if you make a will,
the first will is now valid. The will on
why is it valid?
The testator had the knowledge, he had the capacity, he had the knowledge, and he put a thumbprint. You see, whatever he said was always reduced into writing. It's actually a valid oral will.
So you see that is how you're confusing the point. That is exactly how you're confusing the point, and that is how you end up losing the entire mark. Okay. So guys, please, that is the first thing I wanted to clarify, that a will being signed by a beneficiary does not make it invalid. The second thing that I need to also mention here clearly, that a beneficiary being left out of the will doesn't mean the will is invalid. When somebody is left out of the will, that does not affect the validity of the will. Validity of the will is about, number one, capacity. Number two, the formal requirements, signing and execution and attestation. And then number three are the vitiating factors. It doesn't matter whether somebody has been left out of the will or not. That does not affect the validity of the will. So don't confuse those two things. Those two things are really confused, and people make mistakes regarding those points without knowing. Wills can be signed by beneficiaries. They will still be valid. Okay, so someone else, upon that explanation, somebody has to give us now the validity of this will. First, it is proper if you if you identify which type of will this is and why you think it is valid or invalid. Yes, Tua Joan.
The first will, I think it is an oral will, and it is invalid because we have only been told that it is only the testator who affixed his thumbprint on the will. We have not been told whether it was executed.
No.
No.
Nakuona sana, nakucheki kwa kioo.
I've even listened to my statement. I've seen I'm wrong, whatever I've said.
The only problem is that the next time you make that statement, you'll be making it in a paper. And do you know where you'll realize the mistake? Once you divert that corner that leaves Galleria, once you're in that bus, that ugly bus that comes from Karen, that is when you'll be remembering, oh my goodness. So don't leave that exam room without correcting the point. So make sure that before you say something, note it down with a pencil and then read again and then go through it, because there's a lot of pressure in an exam. You want to write fast and move. So don't be in a hurry unless you're so sure. Okay? So Tua Joan, correct your statement. Quickly. Please, quick.
There was no need for execution and attestation because it is an oral will. There was only need for witnesses to be present when the testator is making the oral will.
You're not answering the question. Is it valid or invalid? Why? Whichever way you decide. Which one? Valid or invalid?
The will is invalid.
Why?
Because in the facts, it has not been indicated whether there were witnesses, whether the people present acted as witnesses to their will.
Tua Joan, unanipima sana. Let us talk to guys. Validity of wills. I will not entertain you getting wrong answers on validity of wills. That is one thing you need not to get a wrong answer. It is the easiest mark to get. Yes, Mulindwa.
Good evening. I hope you can hear me.
Yes.
I would say the written will is invalid because though we are told that there were witnesses that witnessed the testator signing the will, we are not told whether those same witnesses signed that will, which is a requirement under Section 11C.
As a marker, we'll be marking your exam in Naivasha. Normally they're taken to Naivasha. And the budget for marking is around 400,000. And 90% of that is for alcohol. They buy a lot of alcohol when they're marking. So the marker who is reading your paper, I'll be smiling as I put a big X on your question. I pick another booklet. Just by saying what we just said right now, a big X as I sip my wine or my cognac and I move on with another booklet. Guys, what's happening, guys? Do we need to talk about validity of wills again? Robert Wakiaga. Robert.
Yes, Malim. The will made on 20th of August 2014 is an oral will and it is valid because
Why?
present in it are all the ingredients of a valid oral will under Section 9 of the Law of Succession Act. The first ingredient is that the testator had the capacity to make the will.
Yes.
The second ingredient is that it was made before 2 or more competent witnesses because the family members were there.
Okay.
And the third one is that the testator died within 3 months. That would be my answer.
That is the shortest and the clearest of answers. Simple, guys. Simple, guys. Historia, the will was not signed umetoa wapi. Where do you get that statement from? Oral wills are not signed. Now, this statement here, this is what is confusing you. Let me just highlight it for everybody to see. This is what is confusing you. Now, Ashton wrote down the will and the father affixed the thumbprint. That statement is there to confuse you, like it has just done right now. Now, oral wills can also be reduced into writing. Okay? Wambui, the estate, Wambui Gikonyo, the estate of Rufus Ngethe, you know those cases where the deceased person made an oral will in Kikuyu. The people that were there, the friends, translated that Kikuyu language into a paper. You know, not every will reduced into writing is a written will. Okay, not every time you are told whatever that person was saying was reduced into writing, that is a written will. No, for it to be a written will, it must be a will that is written, executed, and attested to as per the requirements of Section 11. Now, where somebody is saying, where you're being told somebody was saying, this is what they said, you've been told, okay? Come here, where I just placed a dot. You've been told that after giving a long speech, Johnston stated, okay? Now, once you're told somebody stated, in the presence of these people, whoever was there, the family, that is an oral will. Now, that oral will, two things can happen to it. The first obvious thing that used to happen to it long time ago, in the old, not really long time ago, but in the 80s, 90s, and early 2000s, is that those statements, because of the fear that you'll forget, you write them down. You note them, as they say, you note them down. Because ordinarily, you won't expect people to cram whatever you said there. This property shall go to this person. No, sometimes you just put it down in paper, and then that will become the evidence of that word. Now, something that will come up again, which will form part of oral will, is that that statement, whatever he's saying, can be recorded. Somebody can use their phone to record an audio of whatever they're saying. That is still an oral will. And also better still, within this age and time, somebody can take a video of him saying whatever he's saying, or he himself can sit down, record a video, and then save that video. So that is still part of oral will. Okay, because with all audiovisuals and videos are still part of, they're still part of oral wills, because the Kenyan system does still not allow the video will. So until you get a system or an act of law, I mean an act of parliament that defines the structures of video wills, all video wills and audiovisuals are regarded as oral will. So it can either be reduced into paper, the audio recorded, or a video taken. All those form part of oral will. So don't look at it and say that this thing was, there's a thumbprint, but it was not signed. No, that is still an oral will. So that answers the question of the first will. That is the will dated the 20th of August 2014. Now, let us go to the second will. That is the will dated. Are we given the date? Now the written will, which is marked as the last will. Somebody tell me, from this statement, whatever is on the screen, what do you think? 2 months later, this person fell and hit his head on the floor and was admitted in the hospital. Okay, the injury made this person mentally unstable. His wife Rahab visited with the cousin's son, and then they told this person need to make a will. They nodded. They wrote a will on his behalf. They brought to him, and then is signed in the hospital bed, was witnessed by Roy and Rahab, and then this guy died a week later. Now, is that will valid? Now, if it is not valid, take us through the process of it not being valid, or if it is valid, give us the reason why it is valid. Alingo?
Yes, Mwalimu. The last will made that was it is a written will and it is not valid. What the basis of the will not being the written will not being valid is that be guided by Section 11 of the Law of Succession Act, where the testator has to affix his mark, and we have seen here that the written document presented to the testator was executed and was duly executed and signed by the testator himself. But now, with regards to the validity of this written will, the testator did not.
Let me stop you there.
Yes.
Now, I'm not saying you're saying the wrong thing. I'm just telling you, when you're answering a question like that, don't if your point is the will is valid, don't start saying the things that would make it invalid. No. If you're saying it is invalid, don't say the things that will make it valid. So if you're saying yes, it is valid, just go straight to the point. Why do you think it is invalid? Don't go to the point that which will the opposite of what you're saying, so that you save on time again, because that part will not be marked.
Okay. Let me start again. The last will that was made, it is invalid. Where we consider the validity of a written will, we look at the capacity. The testator did not have the capacity to make this will. Will be in the question. It says that the injury that he sustained made his mental health unstable. Where the testator did not was not able to duly provide for all the beneficiaries in his will. And if you'd allow me, I'll make reference to the case of Bank versus Goodfellow, which provides that. Okay, which provides that the testator needs to, number one, to have capacity, he must recall all of his properties. Number two, provide for all of his beneficiaries, to recall all of his beneficiaries. And in this last will, we can see that it is only Rahab and her children who have been yes.
Hey, like I said,
yes,
what is making that will invalid? The fact that only Rahab and his son has been listed there doesn't mean the will is invalid. I've said, guys, somebody being left out of the will is not. Okay? Unless the question is telling you that he forgot his assets, or he forgot his beneficiary. So go straight to the point. Why do you think it is invalid? It is invalid because in the case of Bank versus Goodfellow, the court said that a person who doesn't have the mental capacity to make a will is invalid if the testator did not have the mental capacity to make the will. Now you give us analysis and say from the question you're being told that Mr. Johnson fell and hit his head on the floor, and therefore affecting his mental stability. That is the point. Okay, so just go straight to the point so that you save on time again, because there's so many questions.
Okay,
proceed.
Yes, Mwalimu. Okay, now capacity.
So, do it this way. When you see a question like that and you think it is invalid, the first thing you ask yourself, why is it invalid? Okay, you can see that it is invalid because number one, mental capacity.
Mental capacity.
That is the first one. The second one, why do you think it is invalid?
There is presentation of a vitiating factor where the will was subjected to fraud or coercion.
No, there's no coercion there. He was not forced. There was no
Okay,
fraud. They
fraud.
didn't forge the will.
Fraud.
No, they wrote the will and brought to
Oh.
him. So which vitiating factor? There's a vitiating factor there, yes, but which one? Cherono, which vitiating factor?
I think it's the knowledge and approval. He didn't know the content of the will that had been written by him.
Yes, the knowledge and approval. The knowledge and approval. What else is also going to make this will invalid?
Okay.
Tianga?
Okay.
Mwalimu, can we say suspicious circumstance as a vitiating factor?
Suspicious circumstance. In what manner?
Because in the question, in the first will of 20th of August, Mr. Johnston called all his beneficiaries and allocated. Okay, called all his.
In that direction, you're not going to get the suspicious circumstance. When does a suspicious circumstance arise?
Where the beneficiaries of the beneficiaries are also the artists. Okay, no. Okay, I just know if you go with Mwati versus Mwati, I can't put it together.
What are you saying? You can't say you don't know what it is,
no,
but you just know it is Mwati versus Mwati. What is Mwati versus Mwati saying?
In Mwati versus Mwati, the brother and the brothers had colluded to. My thoughts are not together, but I know you need Mwati versus Mwati.
Mwalimu, can I help?
Moyo, Chula. Somebody called Chula Moyo. Are you? Okay, so Chula Moyo?
Yeah, good evening. I was gonna follow up to what you're saying in that the suspicious circumstance could be that the executor of the will is the same person now who gets all the all the property.
That it is. That one is what it is. So remember, guys, we said that it is a suspicious circumstance if the maker of the will is the person getting the substantial chunk of the estate. Okay, so if the person making the will is the person getting everything or a chunk of the will, then that is a suspicious circumstance, and therefore the will shall fail. Okay, so the first thing you need to do first, identify the points. Okay, the first point is the question of mental capacity. You know that is Banks versus Goodfellow. The next one, you know the question of suspicious circumstance. The third one, which is the question of, which is the third one?
Knowledge and approval.
Knowledge and approval. So those are the points that you know that are going to make this will invalid. Now, when you introduce your point, you'll be saying the question, the will, the last written will is invalid for the following reasons. So the first one, you start with the first one. What is your point? Knowledge and approval. So you'll be saying that for a will to be valid, the testator must have the knowledge of the contents of the will and must give his approval. In this case, or in this scenario, Mr. Johnston did not have the knowledge or did not know the contents of the will and therefore signed the will without understanding or appreciating what was contained in that will. That is number one. Number two is the question of mental capacity, which we discussed the question of Banks versus Goodfellow. In Banks versus Goodfellow, the court stated that the will shall be regarded invalid if the testator was not in a good state of a good state of mind, which includes appreciating the nature of business the testator is involved in, among other grounds that you'll be mentioning, things like remembering the assets, remembering the beneficiaries, and then you come and give us your instance. For example, in this case or in the given scenario, the question provides that Mr. Johnston fell, hit his head on the floor, and was admitted in the hospital. At the time he was signing the will, he was mentally unstable, and therefore the will is invalid. The last one is the suspicious circumstance, where you are saying the will shall be deemed as invalid under suspicious circumstance if the maker of the will is the sole beneficiary or receives a chunk of the estate from a chunk of the properties from that specific estate, and therefore the will will become invalid. So the easiest way is don't grapple around it, just note the issues first. 1, 2, 3. 1, 2, 3. The first one, this. The second one, this. The third one, this. Once you have them at your fingertips, then you start writing. But if you start writing as you look for them, it will be hard for you and you might waste a lot of time trying to figure them out. Are we together?
Kabisa.
All right, sawa. Now,
Mwalimu,
assuming, yes,
before you go on, can you also include the issue of attestation?
why?
Because we said that it says that when is that okay, so the will was executed by Johnson in his hospital bed and was witnessed by Roy and Rahab.
Mhm.
So I would introduce the fact that one, the will, Roy and Rahab are beneficiaries, and also we are told in section 11 or in the LSA that when the beneficiaries sign or attest to it, there has to be other independent witnesses. So
That is exactly what I've just explained right now. Mutinda, are you in this class?
Yeah.
On Friday. I've just explained that thing right now. What have I said about that? That is the first thing I started with. What did I say? Mutinda, what did I say? That is exactly what I started this class with, and I was responding to Abdisalan. What did I say?
We look at the issue of attestation.
The question of beneficiaries, I've explained it right now. What did I say about it?
They can be, they are independent, they are competent witnesses.
Mutinda.
So it doesn't
Looks
make
like
it valid.
Lucas, look like you have a long week. You've had a long week. Pick someone. Pick somebody.
Okay, 1 minute. Kimani Wainaina.
Kimani.
Yes. I believe you said when it comes to written wills that where in the earlier instance when we were trying to argue, when some people were trying to argue whether the oral will was a written will and that when it was the property was being bequeathed to the beneficiaries, that it wasn't a valid written will was because the witnesses were beneficiaries there too. But we learned that it wasn't a written will, it was just a transcribed oral will. So yeah.
What are you answering?
I'm trying to take us back to what we talked about with regards to the attestation in a written will.
Okay, and do you know you don't know the question that whatever you're asking is not the question that is being asked.
Okay. With regards to what she was asking, I would also raise the same issue that the written will would also not be valid because one of the beneficiaries or one of the witnesses was a beneficiary, and according to section 13, where a beneficiary is a witness, you need at least 2 more competent and independent witnesses to attest the will.
All right.
Can I?
Do you have children, Kimani, Wainaina? Do you have children?
No, I do not.
Okay. All right. I'll come back to you in a minute. Pick somebody else, Wainaina. Somebody else.
I'll pick Chula Moyo.
Chula Moyo. Chula Moyo. All right. Let me pick somebody. Margaret Nanjala. Is that Margaret Nanjala? Wanjala, yes.
Mwalimu, you said that when a beneficiary has attested the will, it does not invalidate the will. How? Yeah, it does not invalidate the will.
You are saying how, and then you change your mind. What are you going to say about how? Proceed and say everything I said.
Just a minute, I think it has escaped my mind.
Okay.
Mwalimu, I think
Can
I
I
have,
try?
Mwalimu, I have answered myself. When you read section 13, it says only the bequest of that attesting witness, if they are beneficiary, shall be void if there are no additional competent witnesses. So I think I have understood myself. Thank you.
That is exactly what I've said, guys. And you guys keep saying the wrong things. You guys keep saying the wrong thing, guys. The fact that somebody, who was that? That was Wainaina. Wainaina, assuming that you had children and you make a will and you have two children, your son and your daughter, and you bequeath everything to your son and your daughter, and your son and your daughter sign as witnesses. Okay? That will is not invalid. That will shall still pass the validity test, which is under section 11, the question of attestation and execution, and also it will pass the test under section 5, which is capacity. Are you together? But the consequence of that is, while the will is valid, your son and your daughter will not inherit from that estate. They will not get anything given to them. Will not they will not have, because they are not independent witnesses, and they are the only witnesses. Okay, for them to inherit, they need to get at least 2 more people to come and sign the will after them. Okay. In the second instance, if you had a son and a daughter and you give everything to your son and to your daughter, but in this second scenario, it is me and your son who are attesting to that will. Now, in that scenario, your daughter will inherit, but your son will not inherit. Why? Your son is a beneficiary, and for your son to inherit, there will need to have another witness who will sign alongside me as an independent witness. So anytime in a will, there should be at least 2 independent witnesses. Okay, if a beneficiary has signed the will. So if a beneficiary has signed, you need at least 2 independent witnesses. Are you together? So please make sure you understand that. The fact that a will has been signed, for instance, in this case, Rahab has signed the will and Roy has signed the will. Okay, they are the children. They are the beneficiary. They are the beneficiaries as well as they are also the witnesses. But remember, everything was not just given to Rahab and Roy. There are other children. There are also other beneficiaries in this will. So if this will is valid, then the beneficiaries of this will, okay, the beneficiaries of the will still inherit, but Roy and Rahab will not inherit because they are encumbered. That is exactly what I'm saying. So please don't confuse it. The same way people confuse the question of somebody being left out of the will. If you are left out of the will is not invalid. The will is still very valid. If you are not happy, you go to court and you apply for reasonable provisions. That is the only way we can help you. You cannot challenge the validity of a will just because you are left out. No. If the testator was sane, tick. Signed and attested, tick. Kama tuko poa, thumbs up. Give me a thumbs up if you're fine. All right. Now the second question is assuming that both wills were nullified by the court. Discuss the fate of Valeria and Johnny Johnston in relation to the 1 acre in Buxton Town. Okay, assuming that both wills have been nullified. Okay, discuss the fate of Valeria and Johnny Johnston. So let's come to the facts and see what the question is saying. Now, we have a modern townhouse built on a 1 acre land in Buxton City, which was owned jointly with his daughter Valeria as tenants in common. Okay. Now, come down and let's see. Now, from this point, I've noted it down there. The 1 acre in Buxton City shall go to Valeria, since she helped me build the house, and in case she decides to sell it, she you just note those two words, they need not to follow each other. But anyway, let's see. So the fact that I'm thinking about it is an issue. All right, give 10%. Come again.
No, I just said it out for you.
Yes, thank you very much. Give 10% of the proceeds of sale to my dear nephew, Johnny Johnston. Okay, my sister Agatha's son, who is named after me. Okay, so in that case, this will has been rendered invalid. The will has been rendered invalid. What do you think is the fate of these two people? What is the fate of Valeria? And what is the fate of Johnny Johnston, who is the nephew? Quickly, guys, if we get this question quickly, we can get to the next one, and then we jump to other questions. Younger Jennifer, quickly.
The portion that belongs to Johnston will devolve to his estate, and Valeria remains with her portion, and so the gift for the nephew will fail.
Now, why are you saying with the portion that belongs to Valeria?
Because it was a tenancy in common, so which my thoughts today are nini, but yeah. I'm unable to gather my thoughts. It was tenancy in common, so if at all one of the co-owners is deceased, the portion of the deceased person is supposed to devolve to the estate of the deceased person. So Johnston's portion, okay, yeah. Johnston's portion will
calm down. Yeah. Relax, just relax. Julia. Okay. Calm down. So the first thing is that due to the fact that this property was owned in common by Mr. Johnston and Valeria, then upon the death of Mr. Johnston, the portion that belonged to Mr. Johnston shall devolve upon his estate and shall form part of his intestate estate. So Valeria will take the half, and the remaining portion will go to the estate. That is the fate of Valeria. Now, when it comes to Johnny Johnston, we're simply saying that because the will has been nullified, the portion that belong to Mr. Johnston shall devolve upon the estate of the deceased person, which is Mr. Johnston, and shall be dealt with according to the rules of intestacy. And in this instant, Johnny Johnston will not inherit anything from that estate, will not be entitled to that estate because he is not a beneficiary to that estate according to the rules of intestacy. Okay, so Johnny Johnston will not inherit anything because the property shall go back to the estate and shall be dealt with according to the rules of intestacy. But Valeria will have her portion of the property because it was owned in common. And again, should that be sold, half of the proceeds will go to Valeria, half of the proceeds will go to the estate. All right, are we together? If you have a question, you put up your hand. All right. Now, in the event the wills were nullified, identify the would-be administrators and outline the steps the parties have to take towards administration of the estate of the deceased person. Very, very well. Very nice. So, assuming that this will has been invalidated, assuming the will has been invalidated, right there, assuming the will has been invalidated, who will be the administrators and what is the procedure? Quickly. So there, of course, in that instance, whatever I've just highlighted there, this person has been deceased, has been survived by his wives have come, the children, except the first wife, Angelina. So the question, just give me 1 second. The question says that this person is survived by 3 wives and 15 children. Wow. Exactly like my uncle. My uncle was 15, but 1 wife. You know, a very religious man, filling the earth as commanded by the Lord in the book of Genesis. You know? So yes, 15. Nice. Wow. Anyway, so 3 wives, 15 children. Okay. Now, in that case, the question is asking you to identify the would-be administrators and outline the steps. So tell me, who will be the administrators in this question and what is the step they need to follow to administer the estate? Quickly. Cherono.
The administrators will be the 3 wives as the spouse of the deceased, and the process of taking of getting the administration of that estate will be to apply for a grant of letters of administration intestate.
The way you're answering that question, if you're the one marking your paper, will you give yourself a full marks? Can you answer the question in a more clear manner? Like, be procedural, have some legal backing, not really legal backing. Yes, of course, legal backing. What would you have there? Who will be? Okay.
Okay. The administrators of the estate of the intestate estate would be the spouse to the deceased, to the testator, and that would be the wives, the 3 wives.
Where did you get that from? Where did you get that from?
Under section 66 of the LSA, the spouse are in priority to
Do you need to be
apply for the
bribed?
grant.
Do you need to be bribed to say that? Because that is exactly what you're supposed to be saying the first thing. So if you're answering an exam question by saying the estate will be the three spouses, you know, that answer is very lazy. So you need to start by saying Section 66 of the Law of Succession Act. And if you forget about Section 66, at least at the back of your mind, you know very well that it is under under the Law of Succession Act. So if you know it is Section 66, just say Section 66 of the Law of Succession Act provides that in case of administration, the people or the person or the estate will be administered in the following priority. Number one, the spouse in association with other beneficiaries. Number two, beneficiaries, the public trustee, and the creditors in the case, as the case would be. Now, you come back and give us an analysis. Now, in this specific case, okay, there would be administrators for the estate of the deceased Mr. Johnson would be the three wives jointly with the beneficiaries or the children that are above the age of 18, or just them alone. Because remember, they can make an application themselves or together with other beneficiaries. Okay, so don't just throw in there like you're very tired. Okay, the wives, sawa basi, the children, you know. Don't throw in answers like that. Just give us some point. Just say the Law of Succession Act provides. If you don't know the section, just say the Law of Succession Act provides. Full stop. You get your point. So there would be administrators in this case are the wife and the wives and the children, but of course, starting from the surviving spouses, either in their own right or in association with other beneficiaries, and then other beneficiaries, the public trustee and the creditor. But in our case, of course, we just have the three wives and the beneficiaries who are the children. So nobody else. So that is the question to the first part. So the answer to the first part of the question. The next part wants you to discuss the procedure. Okay, what is the procedure? Somebody quickly answer this question. What is the procedure, or what are the steps that the parties have to the steps they have to take or undertake to administer the estate of the deceased person? Now, in the instance where there is no will, so start. What is the first one? Quickly, guys. Quickly. Guys, we have been talking about steps in this class for the last, I don't know how many times. We've talked about the procedure of getting a grant or the procedure of administration. What do you start from? What do you go next to? Somebody who has not spoken. Somebody who has not spoken, guys. Hey, guys, you all don't know the procedure, or what are you guys trying to communicate? Are you on strike? Joyce Okemo, yes?
I would apply for a grant of letters of administration intestate.
So what is the procedure, please?
To do an application to the court.
Who is doing the application? The pastor or the
not
chief?
Not the pastor, the spouses of the deceased.
The proposed administrators, just say that the proposed administrators, the first step, the proposed administrators would make an application for what?
For a grant of letters of administration intestate.
How do they make it, guys? Wewe Joyce, nakuangalia sana na naona unanicheza.
Do a petition
Mm.
and an affidavit.
Petition for probate or petition for
Petition for grant of
succession.
letters of administration intestate.
Joyce, can you just relax and answer the question? If you keep saying one word and then you keep quiet, 2 words, you keep quiet, do you think we are making progress?
Oh, I'm saying you'll do a petition to the court for a grant of letters of administration intestate, supported by an affidavit.
Who will do that application?
The supposed administrators of the estate.
The proposed administrator of the estate. So which application are they making?
The application is a grant of letters of administration intestate.
That is a grant, that is not a petition.
I think I'm lost. Someone else can help.
No, you're not lost. And nobody is going to help you. You are alone, my friend. What you're saying is not, like what I'm saying is this. You're not saying a wrong thing. You're not saying a wrong thing. You're saying the right thing, but you are saying them one after the other. Just say a complete statement. Okay? For instance, if I come to you and tell you that I've been beaten at the police station, my right has been violated, you'll tell me in this instance, you'll file a constitutional petition in the High Court. Okay, so you, as the person whose rights have been violated, file this petition in the High Court. Okay, so even in this instance, don't say they will file an application, or so who will file? Just say the proposed administrators. Okay, would lodge a petition for letters of administration intestate in there. You've not been given the value of the estate, but looking at the assets, just say lodge an application in court. The petition is petition for letters of administration intestate. Okay, that is what they will do. Okay, and then after that, what is the step? The next step. So they have lodged the application. What is the next step?
Next step is to wait for.
What is the next step? Yes, let's go to somebody else. Yes, Lingo.
Yes, Mwalimu, I'll continue from where she left. After making an application to court for letters of administration intestate, the registrar will verify the application itself to confirm all the documents have been presented, and then the file will be placed before a judge or a magistrate. Since it is intestate, there is no will. The judge or the magistrate will confirm the application itself, and once after that, the judge or the magistrate will order for gazettement. And then there'll be gazettement, which will be done. And then now, the next point after gazettement, there'll be an issuance of an interim or a temporary grant. And then after a temporary grant has been issued, the proposed administrators will now prepare a schedule of distribution with regards to the estate of Mr. Johnston, and then after that they'll have to after making the proposed schedule of distribution with regards to the estate of the deceased, the next step is that they will make an application for confirmation of that temporary grant, and that application will be accompanied by the schedule of distribution of the estate. So it means that the application, the schedule of distribution will be attached to the application for confirmation of the temporary grant. And then after that, there will be confirmation of grant, which happens after 6 months of gazettement. After the gazettement, there will be confirmation of grant. And then now the administrators, they'll be now after the grant has been confirmed, what follows next is the distribution of the estate of the deceased person with accordance to the grant that has been issued by the court. And then now the proposed administrators will now have to make a report and account to court as to how the distribution of the estate of the deceased person went. So I believe that is, yes.
Yes, that's the process. That's the process, nothing much, nothing less. So guys, we've talked about this procedure in our classes like 6 times. So you can't miss it out. So please make sure you know the process of administration. So you make application, of course, the petition for letters of administration intestate, attaching the relevant or the prerequisite documents. Then there's verification, there's gazettement, issuance of the interim grant, application for confirmation, then administration. Okay. All right. Question 2, somebody read.
By me, Mwalimu. Question 2. Linda Johnson died testate. The only asset she had was a 5-acre piece of land in Timau, where the family house also stood. She was a widow and had 4 children, 3 girls, Esther, Anna, and Martha, and a boy, Steve. She left a will where she named Bishop Nelson as the executor of the will. As per the will, each child was to get 1 acre of the piece of land, and the remaining 1 acre would be hived off where the house stood and would devolve to all her children in equal shares. After the burial, her will was read out to all her children by Bishop Nelson. The will had fulfilled all the requirements of a written will. However, it emerged that Steve was disgruntled and felt that he needed a bigger share as he was a man. After a while, the deceased daughters got hold of Bishop Nelson and asked him to begin the process of probate. Bishop Nelson became evasive and told them that he did not wish to begin a process where their brother was not in agreement. 2 years down the line, Bishop Nelson has still not begun the process. Armed with the will, Esther, Anna, and Martha have visited your offices for advice, and their matter has been allocated to you for action. 1. Explain the pleadings that is required to enable the parties move forward in probate.
So explain the pleadings that is required to enable the parties move forward in probate. As you do that, explain the steps in such proceedings. So what are the pleadings here? And what are the steps? Somebody. What are the pleadings here and what are the steps? Yes, Wainaina wa Kimani, ama Kimani Wainaina.
I hope I can be heard. I believe the pleadings that would be required here is a citation. So and a citation is essentially where a beneficiary, or sorry, someone who is entitled to the estate of the deceased can make an application, having not previously made an application for a grant, to ask the person who has been issued the powers to take out probate why they have not begun such a process. In terms of the steps in such proceedings, it would be to make an application.
Just wait. What have you said is the pleading?
Citation.
Citation is not a pleading.
Oh, sorry.
You're not saying the wrong thing.
Mm-hmm.
It's like me asking you. My right has been violated. What are the pleadings I'm supposed to file? And you're telling me petitioning. Petitioning is not a pleading. Citation is a process of doing something. So what is the pleading in that instance? I'm not saying it is not citation, but I'm saying there's no document called citation. There's no pleading called citation.
Then I am unsure as to the pleading. Or
how do you move the court? Just give me one. Give me one.
Notice of
1
motion.
second. Wewe unataka kupotea, si ndio? Want to disappear?
No, I did not.
What do you mean notice of motion, guys? I've said this before. Let me just bring my screen up for purposes of. Guys, we talk about citation. Even in the last class, we talk about citation. Did we not, or did we? Yes. Okemwa. When you make citation, what do you do when you under Rule 21? When you are applying for citation, what do you put in? What do you put in? Okemwa, your hand is still up. Rule 21. Rule 21 is this one. Citations. Guys, okay. All right, let's read 21. Some of you have not seen these rules, and I've said you need to read the rules. That is, I mean the probate and administration rules. Very, very important. So every citation shall be drawn by the applicant in one of the forms 3136 as appropriate, and settled by the registrar in the registry. That is citations generally. And then you come to 22, citation to take a grant. Okay, citation to take a grant. So in this instance, we are talking about a citation may be issued at an instance of any person who would himself be entitled to a grant in the event that the person cited renouncing his right thereto. So we're simply saying that if you are, remember when I talk about the question of the qualifications of citing somebody, you must be a person who could be given a grant. Okay, and I gave an example with a school principal, and I said a student cannot cite a principal because if you cite a principal, you are not able to become the principal. In case the principal is removed, you can't be the principal. The person that can cite the principal could be the deputy principal, okay, because the deputy principal can become the principal. The same way in probate, for you to cite the proposed administrator or the executor, you must be somebody who can get it if they are replaced or if they renounce their right. So let's talk about the documentations. You want to read?
Rule 22, citation to
No,
accept or
no, I don't want you to guys. It will take long. It will take long. Give me the documents. Give me the documents quickly. I'm giving the hint. Documents. The first one, guys, we have said, even from the example I've given you, you are not remembering. You guys need to remember things now. You can't forget everything. Mm-hmm. Guys, okay, let's talk about it together. Mulinda, yes, Mulinda.
So the documents required for citation in this case to refuse or accept the grant. The first is the citation form, which the applicant or citer shall draft, and this shall be settled by the registrar as per the probate administration rules. And this form should be prepared in the appropriate form as listed in the document. I mean, in the subsidiary legislation. The second document we need is the supporting affidavit. This is the application for citation. I mean, this is the affidavit that supports the application for citation. The affidavit should verify 3 key details. One, the relationship of the citer to the deceased, the reason seeking the citation, and any other information as the registrar may require or need for verification. And the third thing we need after the citation is issued is proof that it has been served on the citee, because we need the citee.
That is not that's not a key document. So the citation form and the affidavit. What next?
You want me to explain the process?
No, we have the other documents remaining.
The other documents remaining.
Mm-hmm.
Okay. I would say the one, the death certificate.
No, that is not a pleading. All right, let me explain that. Let me explain that quickly because of time. So remember, guys, citation is an instance where somebody has refused to take out a grant. For instance, in our case, let's go back. In our case, this person is appointed as the executor of this estate and he has refused to take out a grant. Now, there's a will and he has been named as executor. So the first thing is a citation form together with affidavit. The next thing that you're going to have, remember, this person has refused to take out a grant. So no matter what happens, he will not take a grant. Somebody mute. The next thing you need to do, remember what we said, that if you make your application for citation and the person cited has refused to take out the grant even after being cited, then somebody mute your microphone, please. If you cite somebody, mute your microphone, please. If you cite someone and the person has refused to take out a grant even after citation, then you need to put in your petition for grant. So the next document you're going to have is the petition for grant. Because remember I said, you can only cite someone if you personally, you can get the grant yourself. So if you cite me, the next step for me is to take the grant, which means put in my application for the grant. But if I don't want to take the grant, then it is upon you now to put your application for grant and the grant will be given to you. That is the question on qualification. So I cannot take the grant unless you have renounced your right or you refuse to take off the grant, in which case I'll be putting in my petition. So in this case, we have the citation form and the affidavit. as well as the petition for letters of probate. Remember, this is a will and there is an executor named in the will. So you petition for the grant. So you put in all those three documents, sorry, all the two documents. So the form and its affidavit, as well as the petition and its affidavit, and of course other accompanying documents. Those are the things you need when it comes to citation. So I've said citation is an instance where somebody has refused to take the grant, so you cite them. How do you cite them? Normally, you can sometimes, all the times, you're going to forget form 35. Just say the citation form, okay? The citation form, or you could say the application for citation, okay? And the affidavit. That is if you forget, if things go sideways and you forget what the document is called, just say citation form or citation application together with the supporting the affidavit. And then the next document you're going to have is petition for letters of probate, because it is a grant of probate. Petition for letters of probate because it is a grant of probate, because the will is there and the will has named an executor. If there was no will, then we have the other two. We have, if there's a will without an executor named, we have the petition for letters of administration with written will annexed. And where there is no will at all, we talk about the letters of administration intestate. So that is the document you'll be putting in when it comes to your citation. So you will need them for purposes of moving forward, because the question says explain the pleadings that you are required to put in for the parties to move forward. Now explain the steps. I've already explained the steps. So somebody summarize the steps. I've done it. I've explained the steps. Somebody, do you want to explain? Summarize now? Jacob, yes, quickly.
Okay, so step one, we file the citation in the appropriate form. Step two, we serve the citation on the citee, and either we serve him personally or by registered post. Step three, we have to wait for the citee's response, and they have to file this response within a timeline of 15 days. If they do not, then the citer may petition the court to have the grant issued to themselves. And then step
that
five.
Is the process. That is the process. That is all. So make the application in the prescribed form. The citee is served and informed of the citation. They put in their response. If they put in their response, the court will proceed and hear the citation and then make an order. If they don't put in a response after the lapse of 15 days, you don't have to name give the specific date or timeline if you forget. If they don't put in their response within that time, then the court will proceed and require the citer to put in the petition for the relevant grant, and then the court will proceed and give the grant to the citer. Full stop. Assume Bishop has approached you and has stated that he is not interested in being an executor or being involved in the estate of the deceased person. What would your advice to him be? What is the advice you will give him? Somebody has told you they're not interested in becoming the executor. How do you advise them? Yes, Abdisalan.
My advice to the bishop, sir, will be to ask him to renounce in writing. He should write he should renounce he's not wanting to execute in writing, and that's enough, I think.
Come again?
I would ask him to renounce his rights in writing to the court.
A letter?
He should write a letter to court renouncing his right to execute. That's all. And if he renounces, then the whoever was entitled will apply for a grant of probate.
Mm-hmm. All right. So that is the question. Yes, Kamunyu. As we go to Rule 18 again.
So he should file a renunciation document, and the regulation you guided us to 21.
What do you mean 21?
Rule 21 of the Law Succession Act. Sorry?
Stop playing. Rule 21 is citation.
I think it was 22, right? Yeah,
22 citation.
The denunciation.
There's nothing called denunciation.
Renunciation document. Renunciation. Okay. Let me stop there.
You better stop there. So there's nothing under 21. And guys, don't go quoting the rules unless you're sure. If it is 21 or 22, don't start quoting rules unless you're very sure that this is the exact rule. So please make sure that is clear. Now, renunciation. This is where somebody is not interested in executing the will. They are not interested in executing the will. Are you together? They're not interested at all in executing the will. So either they are the administrators or they are personal. They are executors of the will. So what do? They of course renounce the right to do so in the prescribed form. Okay. So we look at 18.1, a renunciation of probate, whether of a written will or an oral will, or with the right to apply for administration, may be in one of the forms, 98 to 102. So in the prescribed form, a renunciation of probate by an executor, whether by oral declaration or in writing, shall not operate as a renunciation of any right which he may have to a grant of letters of administration in some other capacity, unless he expressly renounces such right. Unless the court directs for reasons to be recorded, a renunciation of a right to apply for letters of administration intestate may not be retracted. Okay, and then that is what you need to understand. Now, when it comes to a renunciation, the only thing you need to understand is that the first thing you need to do is to do the renunciation or apply for renunciation, or record a renunciation a statement which is done in the prescribed form before the court. Normally, this form is accompanied by a statutory declaration. It must be accompanied by a statutory declaration that you are no longer interested in the renunciation. So, done in the prescribed form, accompanied by a statutory declaration filed in court. Full stop. That is all you need to understand about a renunciation. So anytime somebody is not interested in administering the estate, they renounce their right. And that is exactly why I've said when you are cited, you can renounce your right if you're not interested, or you can take the grant. So if you're not interested, you renounce your right. How do you renounce? By filling out the prescribed form, accompanying it together with the statutory declaration filed, of course, before the court, indicating that you are not interested in the administration of that estate. And then, of course, the court will proceed and give directions as to whoever is supposed to be given or whoever is supposed to apply for the grant, either the cito if the person already cited, or any beneficiary that will be interested in the estate. Should there be one? Are we together, guys?
Yes, Mwalimu.
All right, so that is the question. You get your 10 marks there as well. You get your 10 marks there as well. Question 3, quickly. I want us to complete this question. Somebody read it quickly.
By her will, Miss Gary Marion bequeathed her wedding ring and her shares in Evergreen Limited to her daughter, Fifi. After execution of the will, Miss Marion lost her ring and later replaced it with an identical one. In addition, Evergreen Limited merged with Acacia Limited to form Evergreen Acacia Limited. Miss Marion passed on, and Miss Vera, the executor of the will, has approached you, seeking a legal opinion on whether Fifi would be entitled to the wedding ring, as well as the shares being held at Evergreen Acacia Limited. Relying on the relevant statutory provisions, as well as the relevant case law, advise Vera on the issues in question.
Yeah. So this person wrote a will, Miss Gary Marion, a wedding ring, and her shares in Evergreen Limited to her daughter, Fifi. After the execution of the will, Miss Marion lost her ring, okay, and later replaced it with an identical one, okay. In addition, the Evergreen Company merged with Acacia Limited to form Evergreen Acacia Limited. So Viva or Veva, the executor of the will, has approached you seeking legal opinion as to whether that specific, whether this person can inherit the estate of a deceased mother, whether these properties will be inherited. What is the position of the law to that extent? Quickly, somebody. Yes, Wainaina.
I believe I would advise Viva that the property in question will not pass to
Which property?
the wedding ring and the shares would not pass
Why?
to Fifi because they have been deemed. The wedding ring, what she initially gave to Fifi, changed in form because it's not the original wedding ring. She just replaced it with an identical one. And with regards to the shares, it was shares in Evergreen Limited, but Evergreen Limited merged with Acacia to form Evergreen Acacia. So I would also be led to believe that the shares also changed in form. So in that instance, the properties would not pass to Viva. The relevant statutory provision, I believe, is Section 23 of the LSA.
All right. All right. That is proper. The principle under test here is the question of redemption. So that is the only thing you need to understand, redemption. So what is redemption? Redemption refers to an instance where the property that is gifted, bequeathed in a will, is no longer existing at the time of the death of the deceased person. It is no longer existing. It is no longer there. Okay. So even though the ring was, there's a new ring in question, but that is not the ring that the deceased person intended to bequeath to the daughter. Okay, so the property or the ring will not pass, as well as the share. The shares have changed form, shape, and structure, and therefore the shares also have been deemed are considered to be deemed. So that is the doctrine of redemption. So the question is only dealing with the question of redemption. We talked about redemption. But also remember that where there's been a sale, where the property in question has been sold, then the beneficiary would be entitled to the proceeds of sale. Are we together? So in this instance, if the shares have not been paid for through the merging, if they have not been paid for, that is, if there was a sale, we are not saying there is, but if there was a sale, then the daughter would be entitled to the proceeds of the sale. The daughter would be entitled to the proceeds of sale if the shares have not been have already been paid for. But if they are being paid for, then the property shall have, the shares shall have deemed, and therefore there is no recourse for the daughter. I hope that is clear. Alawi?
Hello. When we were doing this question with Miss Ruto, she mentioned when it comes to the ring, it would pass to the daughter because a ring is a personal and a household effect, which is defined under Section 3.1 to include articles of adornment and ornaments. And so the ring would pass, and we wouldn't have to talk about the principle of redemption.
Wakili. Wakili, do you know what you're saying?
Oh, I'm just relaying what Miss Ruto said, and I would just like to know your thought on that.
All right, this is my thought, and of course, with the due respect to Madam, that is not the right position. I mean, personal and household effects, where are they relevant? They are relevant, number one, during intestacy, where there is no will. Okay? And in this instance, we said that the surviving spouse will be entitled to them. The surviving spouse will be the one entitled to the personal and household effects. Okay? Now, where the surviving spouse is not, I mean, there's no surviving spouse, then this specific idea is not relevant. Now, the question is not whether this is a personal and household effect. No. If this lady married the mother, which is not the case, if the lady in question, the beneficiary, is a surviving spouse, then we'll be saying that the personal and household effects will go to them. But remember, that is not what is in question. The question simply says that there was a ring. We are not saying whether she's entitled to it. And there is nowhere in the Law of Succession Act which says that personal and household effects will pass to the beneficiaries or to the daughters. That is not the question. The question simply is, there was a ring that was bought. It was given to the daughter. That ring was lost, and then a new one was bought. Okay? A new one was bought. So that means the first ring as a deemed, the first ring as a deemed. Are you together? The first ring as a deemed. So it will not pass under the will. That gift under the will has failed. And therefore, the new ring that has been bought will only go to the daughter under the rules of intestacy, because it was not covered in the will. Whatever was covered in the will is long gone. If you buy a laptop and it was lost, okay? If you buy a laptop and that laptop has been lost, and you buy a new one, the same laptop, because the same people that make the laptop will make the new one. So the one that was in the will as a deemed, okay? It has a deemed. Are you together? The doctrine of redemption. It has a deemed. Why? It is no longer there. Whether a new one has been bought or not, the one that was in the will is no longer there. Are we together? And then the one that is now here was not the one covered in the will, and therefore it will go to the lady under the question of intestacy. But insofar as the will is concerned, the property that was in the will has been deemed. So please understand that concept. It is very, very important. You get what I'm saying? You get what I'm saying?
You are very
Yes,
right.
thank you.
Yes,
Yes,
so what
Madam.
was in the will as a deemed, whatever has remained will only go to the lady under intestacy, which is under section 38. Okay, which everything that has been left will go to the lady, because that is the only surviving child. That is why the deceased person has left behind no surviving spouse but a child. Everything will go to the child under section 39. But the main principle being tested here is redemption. The ring that was given in the will is not there. Redemption. The shares that were given to her are not there. ademption. Are you together? So I hope you get what I'm saying without belaboring on the point. Alphonse, what is your question? As Mr. Beba is asking, as we read the next question.
Yes, mine is actually a clarification. You've addressed my concern while answering her. So my question is this: is this a blanket way of understanding these things, such that whenever the deceased or the testator makes a bequest, and the bequest changes its form in any way, then it means that it has been deemed? And the specific example I had in mind is where, for example, they're giving out, or they're gifting a land. So then this land is later on, part of it is sold. For example, it was 5 acres. Then it is one acre or 2 acres is sold, and it remains as 3 acres, for instance. So as that one also deemed, or what will apply in that scenario?
No, it does not deemed. It is still there. Whatever is there. Remember, ademption simply means the property is not there, is not existing anymore. Why is it not existing? Destroyed by fire or natural calamity, stolen or transferred. So that land, is it acquired by the government? Ademption. Is it wholly transferred fully to somebody else? Ademption. So that is the test is it existing? If part of it is still existing, you get the part. If it is sold and the purchase price is not yet paid, you are entitled to the purchase price. So the test is, has it disappeared, or has it changed form? For instance, if I give you my maize, that all my maize on my land will go to Alphonse, and then that maize has been harvested, it has been sold to a company, the company has made it into unga. Will Alphonse say that he is entitled to unga? No, you can't be entitled to unga. You are only entitled to maize, but now the maize has changed form. You are not entitled to the unga. That is ademption. So if the form has changed entirely, whereby, you see, remember guys, when you give a gift, you must be able to identify the gift by saying, this is the gift, hii ndio gift. Okay? There is no gift that is not identifiable. It must be identifiable. That is the rule on certainty. So if I give you shares, shares are given numbers. So I'm giving you share this, this, and this, and this. Every share has a number and has a unique identifier. Okay? Now, if those shares are transferred and the form has changed, now they're belonging to another company under different numbers and everything else, that is ademption. Okay? If I give you a laptop, that laptop has a number. If I give you land, land has a number. If I give you a car, that car has a specific number or identification. So the property must be clearly identified. But if the form changes to something else, okay? If the form changes to something else, I gave you, let's say, my wristwatch or my jewelry, and then they have been transformed into something else. They have been melted and then they have been transformed to a watch. You're not entitled to the watch. You're not given the watch. You're given the necklace. So if the necklace is now, melted into a watch, you don't get the watch. So if the form has changed to another identity, that is when you're saying the gift as a deemed. It is no longer there. We cannot identify it specifically. We cannot say this is the ring. We know very well the ring was lost. So this new one you bought, no problem. I will still have it, but I cannot have it under the will because it has been deemed. Tunaelewana?
Yes, tunaelewana. Thank you.
Read question B.
Mr. Beba died testate, leaving a will which had, among others, bequeathed one of his properties to Mr. Kariri, a business partner who was not related to him in any way. Upon his demise, it was established that the property bequeathed to Mr. Kariri was one of Mr. Beba's houses in Nakuru, valued at the sum of 25 million Kenyan shillings. While Mr. Kariri has welcomed the bequest made to him by the late Mr. Beba, he has also laid a further claim to the estate by informing the family that the deceased owed him an amount equivalent to 30 million Kenyan shillings arising from their business dealings. He has threatened to claim the same as a creditor of the estate during the process of probate. The late Beba's family members have vehemently opposed both the bequest as well as the claim of 30 million Kenyan shillings. Using relevant statutory provisions as well as judicial decisions, advise the parties in respect of the bequest and the claim for 30 million Kenyan shillings.
Yes. Which principle is this? At least you know that we discussed this. Which principle is that? Which principle is this? Yes. Which principle is this? Cherono?
It is the principle of presumption of satisfaction.
What does it say?
It states that if the testator has bequeathed okay, if the beneficiary who has been bequeathed by the testator, no, oh, how can I put it? If the testator has bequeathed a beneficiary who he owed an amount of money,
what's happening with you? Can you relax? Calm down. Breathe. Relax. Chill. Sip some water and then answer. What is the doctrine of presumption of satisfaction? What are we presuming? That is what I'm asking.
Okay, if the deceased, okay, this instance, if the deceased owed you,
Don't use
owed a
me.
beneficiary.
Just give.
Okay.
Give a general statement. Answer the question. What is the doctrine of presumption of satisfaction? The doctrine is, or the doctrine
Okay,
presumes what?
Okay, if the deceased owed a beneficiary and bequeath something in the will to the same beneficiary, it will be presumed that the debt has been paid.
No. So if they owed me 10 million and they left me 5 million, the debt has been paid.
No, if they bequeath you the same amount of money they owed you or more,
what is the principle? What is the principle? What is the principle? Gadoni, what is the principle? Robert, we can't hear you, Gadoni. Robert?
Yes, Mwalimu. The principle of presumption of satisfaction presumes that if a deceased person bequeaths an estate to a creditor, then
you
whatever
can't
is
bequeath an
bequeathed.
estate.
Okay, bequeath. Okay, if we bequeath an item.
Just say a gift. Just say a gift.
A gift. Okay, if we bequeath a gift to a creditor, then the gift is presumed to be in the satisfaction of the debt.
All right. So simply mention that under the principle of satisfaction of presumption of satisfaction, it is presumed that anything that is bequeathed to a creditor in the will is done so in the presumption of satisfaction of the debt that was owed by the deceased person to the creditor. Okay, that is the general principle of law. And then you give us the analysis of your from the question. Now from the question, Mr. Beba owed Mr. Kariri. Is it Kariri? Mr. Kariri, Kenya shillings 25 million, and sorry, 30 million, and he bequeathed Mr. Kariri 25 million in the will. Therefore, it shall be presumed that that 25 million is towards the satisfaction of the Kenya shilling 30 million debt that was owed. Therefore, 25 million shall set off against the 30 million debt that was owed. Now, the conclusion therefore is that Mr. Kariri cannot claim the sum of 30 million against the estate of the deceased person, hence can only claim 5 million. So you deduct 30 minus 25, and then you claim the rest. That is the principle. Galoni or Alphonse, what is the question?
Mwalimu, I have a question. I'm not sure whether Gathoni. Yeah, okay. My question is, I'm reading is it the first schedule, paragraph 64, And it's saying that when a debtor bequeaths a gift to his creditor, it's basically on presumed satisfaction of debt, where a debtor bequeaths a gift to his creditor and the gift is equal to or greater than the debt, there shall be a presumption that the gift is intended to satisfy the debt and not be taken in addition to payment of the debt. So while I understand that, yes, you taught us that it can be taken either in partial satisfaction of the debt or in full satisfaction, this regulation is like it's implying that it must be equal to or greater than the debt for us to presume. So I was having troubles reconciling this with what I had initially understood.
No, that was just that was just a statement that was made in the act. That is the Law Succession Act, where we are saying that if in any instance you have given something equal, the general rule is if I owe you 1,000, I might leave you something in my will of 1,000 shillings. So the general rule was anytime you get something equal to what you are owed, then identically it is assumed that that thing that you have received is in the satisfaction of the debt that you are owed. And the same applies to when whatever you are given is more than what you are owed. Now, the same principle is applied in the reverse, that if the deceased person owed you 30 and they give you 25, that 25 will be taken in partial to have been made in partial satisfaction of the debt that was owed. And there's a lot of case laws on that as well. You can check that out. So it goes both ways, because again, would it make sense even under equity and under the rules of fairness that somebody owed you 25 million, they have given you that in the will, and still you're claiming another 25 million? It can't work. Can't work. So that is what you're saying. So it applies both ways, either the front or the back. That is, you move with the numbers, or you deduct the numbers. So if you're given if you're given equal, satisfaction. More, you deduct. Less, you set off. Okay, so it applies both sides. That is the principle of satisfaction of debt, the doctrine of presumption of satisfaction. So we presume that what you are given is to satisfy the debt that was owed to you. So you cannot say that hii umenipea tu lakini pay the debt. No. Are you guys together?
Yes, we are. Thank you.
All right. So guys, a question quickly. Do you guys think we can do question 4, and then we can add John, or are you guys too tired?
Let's do it.
Question 4, somebody read quickly.
Let me read. Oscar was a wealthy and generous man who was well liked by his community. At 70 years of age, Oscar decided that he has accumulated enough wealth and will start empowering the needy by giving away some of his wealth. He hived off 5 acres of land and subdivided it into half-acre plots that he intended to transfer to the neediest families in his village. He brought these families and showed each one of them their allocated plot of land and allowed them to settle in while he processed their new title deeds. On his way to collect the new title deeds from the land's office, Oscar suffered a heart attack and was admitted to hospital for treatment. Despite their best efforts, the doctors informed him that he has less than a month to live and should put his affairs in order. Since he was very grateful to his driver who acted swiftly when he suffered the heart attack, he called his family and said as follows: "I want my driver to have my Range Rover Sport and my Maybach when I die. Make sure you give him the logbook and the keys." When the family tried to look for the logbooks, they could not trace them. They were later informed that the logbooks were held by a bank as collateral for an outstanding loan. Oscar died 3 days after making this statement. His family has approached you for advice. Using relevant authorities, advise them on the following. The first one, the legal effect of Oscar's generous actions towards the needy families and his driver.
All right. So what is the legal effect of this for generous actions? What is the first one and the second one? So the first one is the needy families. The needy families, he was giving his pieces of land. The question says that he has hived off 5 acres of land and has subdivided them into half acres each, with a with intention to transfer to the needy families, like you've seen. And then the question also says that he was on his way to collect the new titles from the lands office. Okay, on his way to collect the new titles from his office. And then also number 2, you're being told that he has given his Range Rover and sporty cars. This might have been a Luo guy. This Oscar is Luo. Yeah, he's given his car to the driver, and he has clearly indicated, make sure you give him the logbook and the keys. When the family tried to look for the logbooks, they could not trace. The items. They were informed that the logbooks were used as collaterals on an outstanding loan. Oscars died 3 days later. So tell me, the first instance is regarding the generous actions towards the needy families, and then the property bequeathed to Oscar, the driver, not Oscar, I mean the driver. Okay, guys, quickly, guys. Guys, come on. Yes, Owino Alphonse.
Yes, let me give it a shot. As regards the generous actions towards the needy families, I'd say that those ones passed, since we are told that he was going to collect the titles. Now, after hiving off the half-acre plots, hiving off 5 acres of land and subdividing them, they had already been transferred. And when he got that heart attack, he was going to get the title. So it means that the titles were ready. So I believe that those one will pass. Now, as to that of the driver,
they pass as what?
They will pass as gifts inter vivos.
Okay.
As to the second one, since he was very grateful to his driver who acted swiftly, he told his family that he wanted his driver to have the Range Rover Sport and the Maybach when he dies, and he was to be given the logbook and the keys. Now, I had an issue with that because I'm not sure whether it's an oral will or a gift in contemplation of death, but I'd go the oral will route. Okay, I'll seek guidance on that. Let me just stand guided on that.
Well, somebody else. So guys, the first properties. So the first set of properties, they are the pieces of land. They will pass as gifts inter vivo because they were made. The titles were processed during his lifetime, so they are gift. So they are gifts inter vivo. Okay, they shall pass to the estate of to these needy families, and they will not form part of the estate of the deceased person. What about the car, the Maybach and the Range Rover Sport that are supposed to be going to the driver? To Joan?
I would say that it is gift in contemplation of death because he has received information from the doctor that he has less than a month to live, and the gift did not pass because there is no delivery that has been done, either of the gift or anything that signify ownership of the gift.
Yeah. So will it pass?
No, the gift will not pass because
Why?
some of the conditions that should be fulfilled for the gift to pass, such as now the delivery of the gift itself or anything that signifies ownership, has not been done. The logbooks that were supposed to be given to the donee have not been delivered to him because they were in the bank. They had been used in the bank as collateral.
So what happens in that instance? Okay,
The
because of time, let me just explain. So the gift will pass because this person has provided direction in terms of giving means to possession, which is the question of the logbook and the keys. The logbook, of course, is in the bank, but of course the keys are with the family. So the only thing they can't find is a logbook, so which is in the bank. Okay. Now the gift will still pass. The gift will pass. Okay. The gift will pass because this person has made a gift in contemplation of death and he has died. Okay. The gift is a movable property, and he has given directions in terms of the means of access, which is the key and the logbook. That passes. The next question or the next issue there is that these logbooks were used as collaterals for a loan in the bank. Okay. And you're being told that the family wants to ensure. That is part 2. So I'm already under part 2. So this gift should pass. This gift should pass. Are you together? The gift should pass because of what I've already explained. That is part 1. Okay. Now the additional point that I want to make is in reference to point B. So Oscar's family wants to ensure that Oscar's wishes are implemented. Advise them on the proper legal process of achieving this. Okay. Now remember that these properties are used as loans. They are used as as collaterals for loans. Now, in the instance where there are 2 options, the first option is that the family will pay. The family will pay the loan and then discharge the vehicles and give them to Oscar. Or in an instance where the family is not able to settle the loan, then the cars will be used as collateral. That is the rule when it comes to that. So when you're told that the cars have been used, the item that was given as a gift in contemplation of death was used as a collateral, then it means in any instance where the family or the estate is not able to pay the loan, then the same asset that was issued, that was used as a collateral, will be, so that was given as a gift in contemplation of death, will be the one used to repay the loan. So they'll sell the car and pay the loan. That is if they're not able to pay. Now, in an instance where they want to pay, because you're being told that they are insisting that the wishes of Oscar must be actualized. So they need to pay the loan, discharge the vehicles, and give them to Oscar. So remember the rule when it comes to gifts in contemplation of death is that the property shall pass if they meet the conditions. Number 2, if those properties are used as collaterals to secure some facilities, then the gift will only pass if the estate of the deceased person are able to pay the debt. If they're not able to pay the debt, then that specific property can be used as a means of payment. They can sell the property and use it as a means of settling the deceased person's debt. And in that instance, the property will not pass as a gift in contemplation of death. So tunasema ulipewa gari, lakini hii gari ilitumiwa kama collateral. So tutalipa loan na tukupea gari, to discharge gari, na tukishindwa kulipa loan, hii gari ndio tutatumia kulipa hiyo loan. So in that unfortunate event, you will not get the car because we shall use it as a collateral. As a repayment mode. Okay. Now, in the instance where they want to pay, then of course you know that is the question of first repaying the debt, and then after repaying the debt, then they discharge the property and then give the driver his share. Now, in this instance, the first thing that they will have to do is they have to pay the debt from the estate. They'll have to pay the debt from the deceased person's estate. Okay, so that is a debt from the estate. They'll have to pay the debt from the estate of the deceased person and then apply for the discharge of the logbooks, once they apply for the discharge of the logbook, the discharge will be, the logbooks will be discharged. That is a right payment, and then the same will be given to Oscar. But of course, the procedure in terms of that is, if it is done at the point where they don't have a grant, of course they have to make an application, which is a simple limited grant for purposes of repayment of loan. Remember that grant can be used to allow the deceased person, or to allow the estate of the deceased person to repay the loans or repay the debt of the deceased person. So that is a simple limited grant. Or in the alternative, they'll make an application for grant. Once they have the grant, they will liquidate the estate of the deceased person and then pay the debts and then have the logbooks discharged, and then that will be it. Are we together?
Yes.
So the main concept you need to understand there is that when the item given as a gift in contemplation of death is used as a collateral, then the passing of that gift will depend on whether the family is able to pay the loan. If they're not able to pay the loan, then sadly, the item given as a gift in contemplation of death will be the one to be used as for repayment, to settle the debt. That is clear. So guys, don't confuse gifts in contemplation of death. Do some reading around that. So the fact that this person, he doesn't have to give the key. He has already given directions. He doesn't have to give the physical key. He has given directions, and he has told. Remember, this person is contemplating death. He doesn't have to have the key there. He can tell you the key is in my office. That is him giving you the key. He has told you where to get the key. Or the logbook is in this place. Go and give him. So he has given directions in terms of possession and logbook and all that. So please do not confuse that. So that is the end of the class. We'll do question 5 and 6 in the next class, as we do question 1, 2, 3, 4 again of the other year's paper, which is 2023 November. I'm moving on very well. So the next question is preparation of a will. This one, question 5, preparation of a will. So come to the next class knowing how to prepare a will. We shall go through it together as well. Preparation of wills. All right, guys. So I think I will leave you there. Don't forget to read and ask questions so that we are all on the same page. Have yourself a beautiful long weekend. Take care of yourself, and I will see you when I see you. Guys, ask for this recording right now. The recording has been stopped. Please ask for it right now. Not tomorrow, right now.